Hello, law students and legal practitioners. Today, we will analyze the case of Claudio versus Commission on Elections, GR number 140560, decided by the Supreme Court on May 4, 2000. Let's begin. Here are the legal doctrines of the case. For purposes of the one-year prohibition under Section 74(b) of the Local Government Code, the term recall refers only to the recall election itself, not to the preliminary acts of convening a preparatory recall assembly, PRA, passing a recall resolution, or filing a petition for recall with the COMELEC. The statutory limitation applies only to the exercise of the power of recall by the electorate, which is done exclusively through a recall election. Recall is a process consisting of several stages: initiation, verification, and election. However, while the process may begin with the PRA or with the gathering of voter signatures, the legal limitations in Section 74 apply only to the conduct of the recall election, because only the electorate, not the PRA, exercises the sovereign power of recall. The purpose of the one-year prohibition from assumption of office is not to create a political moratorium or period of repose, but to ensure that the electorate has a reasonable basis to judge an official's performance, which judgment can only occur at the ballot during the recall election, not during the preliminary recall proceedings. The phrase, regular local election, in Section 74(b), refers only to the actual election date, and not to the campaign or election period. Interpreting the prohibition to include the election or campaign period would unduly constrict and effectively emasculate the people's constitutional right of recall. Here are the relevant facts of the case. Jovito O. Claudio was elected mayor of Pasay City in the May 11, 1998 elections and assumed office on July 1, 1998. In May 1999, several barangay officials in Pasay City began discussions on initiating recall proceedings against him for alleged loss of confidence. On May 29, 1999, the Preparatory Recall Assembly, PRA, of Pasay City, composed of barangay chairpersons, kagawads, and SK chairpersons, adopted Resolution No. 01/1999 initiating the recall of Mayor Claudio. A petition for recall was formally filed with the COMELEC on July 2, 1999, more than 1 year after Claudio assumed office. Mayor Claudio opposed the recall, arguing that the recall proceedings violated the one-year prohibition under Section 74(b) of the Local Government Code, that the PRA lacked the required majority, and that the pendency of an election protest questioning his proclamation constituted a prejudicial question. In its resolution dated October 18, 1999, the COMELEC dismissed the oppositions and gave due course to the recall petition, finding that the PRA was duly constituted, the recall resolution had sufficient signatures, and the petition was timely filed. The COMELEC later set the recall election on April 15, 2000. Mayor Claudio then filed a petition for certiorari and prohibition before the Supreme Court, while the PRA filed a separate petition for mandamus to compel COMELEC to set the recall election date. Issue 1. Whether the one-year prohibition under Section 74(b) of the Local Government Code bars the convening of the PRA and the filing of a recall resolution within 1 year from assumption of office. No, the one-year bar applies only to the recall election, not to the initiation of recall proceedings. Section 74 regulates the exercise of the power of recall, which under Section 69 belongs exclusively to the electorate. Since the electorate exercises this power only through a recall election, the statutory limitation cannot apply to preliminary steps such as PRA meetings or filing of recall petitions. Although the PRA met and adopted the recall resolution less than 1 year after Mayor Claudio assumed office, the recall election itself was scheduled more than 1 year later. Hence, there was no statutory violation. The initiation of recall proceedings did not amount to the exercise of the power of recall. Issue 2. Whether the phrase regular local election in Section 74(b) includes the election or campaign period. No, it refers only to the date of the regular local election. The law is explicit that the prohibition applies to the holding of recall elections within 1 year immediately preceding a regular local election, not the election or campaign period. Had Congress intended to include the campaign or election period, it would have expressly provided so. Construing the prohibition to include the campaign period would drastically shorten the already limited recall, freedom period, and undermine the constitutional policy of making local governments accountable through recall. The recall election scheduled on April 15, 2000 was therefore valid. Issue 3. whether the Comelec committed grave abuse of discretion in giving due course to the recall resolution and ordering the holding of a recall election. No, the Comelec did not commit grave abuse of discretion. Findings of fact by the Comelec regarding PRA membership, sufficiency of signatures, and compliance with recall requirements are accorded respect absent grave abuse of discretion. The Supreme Court found no arbitrariness in COMELEC's determination that the PRA had a majority, that the recall resolution was validly signed, and that procedural objections raised belatedly by petitioner lacked merit. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.